Estamos a Moçambique, visitamos distrito que se chama Maracuene, 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 Maracuene.
I'd just like to formally welcome everybody to our third webinar for MyKludo. And for those of you that are not familiar with MyKludo, it is a marketplace for investigation professionals where clients can come and obtain 3 free quotes from completely independent investigators and then engage directly with the investigator of their choice. I'm really delighted to be able to welcome Eleonora Di Michele to do a presentation on the recent changes to the Reportable Conduct legislation in New South Wales. So myself and Eleonora go back some time. We first bumped into each other back in the late 90s when the pair of us were delivering interview and investigation training to the joint investigation teams in the New South Wales Police Services. So Eleonora joins us today, and she's got over 40 years of experience in the welfare services, and for the past sort of 24 years she's been providing consulting services in the child protection space. So she has a wealth of experience across a whole range of child protection issues, and her consulting services include facilitating training and doing interview children training, responding to child abuse, and also safety orientated child protection practices. So I'm going to hand over to Elle now, who's going to go through her presentation and facilitated conversation with regards to the recent changes.
Okay, thank you, Harriet. Can everybody hear me? I'm a little bit new to this technology, so if I drop out or if I interrupt you, then I'm going to make my apologies now. I've got a lot of experience in face-to-face and little experience in this new Zoom world. So thank you so much for inviting me, Harriet. I'm absolutely thrilled to work with everybody. As Harriet said, I have been in the sector for a long time. I started in 1979 actually as a street child protection worker, and have had the really good fortune of working in lots of different organisations and also in lots of different positions, including statutory child protection. And I also did a lot of work with the Ombudsman in relation to reportable child deaths, and also have been responsible for training many organisations in how to conduct investigative interviews with children, particularly in the context of allegations against employees. So this is a particular interest area that I've had in terms of supporting organisations create safety for the children and vulnerable clients that they might have. So what I'd like to do is I'm going to walk us through a presentation. Now, I know that there's just a small group of us, so I'm just wondering whether we want to quickly introduce ourselves and then we'll march on with the presentation because we've only got a short period of time. So would someone else like to quickly introduce themselves? We've heard from Harriet. Anyone else would like to say hello to the group?
Hi, Eleonora. Harriet knows me. It's Tracy Bosnich from Wise Workplace in New South Wales, Sydney. I'm also formerly a solicitor with Legal Aid, so I've also had a lot of exposure to, unfortunately, reportable child deaths, and I was on the other side representing the parents, because Legal Aid is a defence organisation, so it would be in those sort of situations, and including staff within a facility that had been charged with, you know, reportable conduct, sexual assault, physical assault, things of that nature.
Great, welcome to the group.
Thank you very much for today too. I think it's very, you know, taking a lead role in doing something that, you know, is started on the 1st of March and then COVID starts and no training's been available for anybody.
Yeah.
I know, timing's been perfect, hasn't it?
So look, thanks very much for organising it.
You're welcome. Thank you. Thank you, Harriet. Anyone else like to introduce themselves quickly before we march on?
Yep, very quickly, Wendy Clarkson, former psychologist with Corrective Services, former manager professional conduct with Department of Juvenile Justice, and consultant investigator for about 20 odd years.
Great, well, welcome. Anyone else?
Everyone's
Okay.
being very shy.
Yeah, everyone's shy. That's exactly right. Okay, listen, we'll march on because we've only got a very short period of time. Just got to quickly want to acknowledge the traditional owners of the land on wherever we may be working today. We may not be all in central Sydney, so I want to pay our collective respects to elders past, present and emerging. The other thing I want to say is, unlike some of our colleagues on the call, I'm not a lawyer, I'm a social worker. So I'd always invite you to check everything that we talk about today, because this is not legal advice. This is just really orienting you to some of the changes that are coming in, or that have come in. And the Office of the Children's Guardian is always very open to contact to help, I guess, settle some of the dust of the changes to the legislation. I'm not an employee of the Office of the Children's Guardian. I'm an independent practitioner. So, we're all learning at the same time, which is fantastic. What I would like to do today is, rather than this be just a head talk where I do all of the speaking, I would like to, I'd like to actually facilitate a conversation between all of us. So, as we're going through the material, if there's an issue that's new for you, or you want to better understand what it might mean for your practice as an investigator, or as a lawyer, or as an executive, then please speak up, because I think that one of the beauties of this opportunity is that there's a lot of deep experience on this call. So we can see what's working well, what are we understanding clearly, and what isn't working so well, and maybe we need to wait to see if there's any precedents going to be set in the near future, etc. Because the beauty of new legislation that's released during a pandemic is that we don't know how it's going to land. So the timing's been perfect. Okay, so it's really around us all talking with each other. So I'm going to invite participation. If you want to make a comment, please just put your hand up or just give out a shout out, and we'll hear what you have to say. Now, the program is ambitious to the point of almost being delusional about how much I want to cover. So I am going to quickly go over the key changes of the legislation. There are, and the beauty of the changes is that it's brought some much needed clarification from some of those ambiguous things that were occurring in under the Ombudsman's legislation. The other thing that the new legislation has done is increased the catchment, which for some of us brings us great joy, particularly as we kept very close observation of the Royal Commission, and for others it's created anxiety because now it captures us, where we may have been exempt previously. So we'll have a look at now, what are the agencies that are now covered. We'll also look at the definitions of reportable conduct, and the beauty of the new legislation is that it provides some greater precision, and it also gives us a sense of what do we need to take into account when we're trying to make a finding, using more than sometimes vague concepts that were included in the Ombudsman's legislation. Then we'll quickly look at the reporting obligations and the timelines, and then we'll see, have a quick touch on the child safe standards. But clearly I want to tap into the wisdom of the group, to say, particularly if anyone has conducted an investigation under the new legislation, how's that landed for you? What are some words of wisdom that you can share with the group? What worked well or what didn't work so well? Now, this presentation is going all over the place because, quite frankly, I don't know what I'm doing with the PowerPoints. Okay, so let's have a quick look at what has started. So, can everyone see my screen? Okay, rightio. Okay. So clearly, the first change that's occurred is that it was shifted from the Ombudsman, but also it was shifted from two other organisations as well. So we've got a streamlining of the legislation, which is fantastic, and it also means that it's streamlining of reporting. So rather than doing 3 separate reports, we now just need to do one. And and the beauty of the streamline also means that the Office of the Children's Guardian can keep a finger on the pulse in all 3 areas, rather than relying on sometimes overwhelmed communication systems between different agencies. The other thing is that, you know, the principles of the child safe standards have been adopted and their operationalising is now becoming a greater imperative. And also there's a greater catchment to the entities that have been covered by the legislation. What we didn't have previously was the religious entities. Now that's going to create some anxiety for a lot of people, because, and I think that the Royal Commission has shown really clearly that there's a need to capture those entities, absolutely, in terms of safeguarding children. There's also, one of the biggest changes is also the sharing of information. So the sharing of information from the Ombudsman and also to the Ombudsman is much closer, or almost mimics exactly the exchange of information that's under Section 248 of the Children and Young Persons Care and Protection legislation. So the Children's Guardian has as equal power for information exchange now as the Secretary of the Department of Communities and Justice, which is fantastic. I mean, so everybody can talk to everybody, because I think we all know that child abuse thrives in secrecy. So that's a great change. Now, what hasn't really changed, although that the paramountcy principle, Section 7, has been introduced to the Children's Guardian legislation, it has always been there under the child welfare legislation. It's Section 9 of the Children and Young Persons legislation. So I think all of us have worked to that principle, but now it's been made very explicit in the Children's Guardians legislation. And now the other thing that this legislation has done is it's also brought under its umbrella, apart from adoptions and everything else, the employment of children, and that hasn't changed. It's all that's done really is it's moved from the Ombudsman to the Children's Guardian Act. Oh, what am I doing? Oh, sorry about this. Okay. All right. Now, are there any questions so far? Pretty obvious. Yeah. Okay. So these are the other little pieces of legislative changes. It's mainly around language. So an agency is now called a relevant entity. The designated agencies are now called a Schedule 1 entity. So there's a little bit of language change, but nothing that's really outside anything that we need to be worried about. The main difference, and I'll talk a little bit about it, is the reporting. So rather than having a Part A and a Part B, you've got your 7-day notification form, and also you've got your report form as well. Now, all of that is on the the Children's Guardian's website, all the forms that you need to take. Now, these are the entities that have been captured by the legislation. Can everyone see that? Yeah. So the big difference, well, the two main differences are public authorities, and that becomes important when we start to talk about what's inside of work and what's outside of work. And also the religious bodies have now been captured by the changes. And the other thing that's much clearer is the catchment of family group homes, things, organisations like, overnight camps, accommodation and respite for children. So we're really looking at a much broader net to make sure that children in a variety of different contexts are captured. And I've just finished doing some work with the YMCA, and certainly their camps have been captured by the new legislation. Okay. All right, now, religious bodies. This is an area that is new to our practice, and I think that this is what's creating most anxiety for some organisations, that their organisation is now being captured. So we've got any organisation that has been set up for religious purposes, and also an entity that establishes or directs, controls or administers an education or other charitable entity that's intended to be and is conducted in accordance with religious doctrines, beliefs or principles. So things like Sunday school, education programs, all those activities that religious entities undertake to engage in religious education. The other change is the definition of an employee of a religious body. So what we're looking at here is anyone who holds or is required by a religious body to hold a working with children check. So it really is now starting to spread the net within those organisations.
Mm.
Has anyone done any work with religious entities at this stage?
Since so Eleanor, you mean since the new legislation came in?
Yeah, since March, the 1st of March.
I don't know if anybody would have done much since then.
Yeah.
The new matters have been very thin on the ground, I think.
All right.
I'm
Right.
about to embark on some.
Oh, yeah?
So, you know, I'm trying to get our, and Eleonora, I'm trying to get our investigators. I did like a tip sheet for them when the legislation first came in, but yes, it's definitely a religious body, and I'm being grilled within an inch of my life next week to make sure I can demonstrate that not only myself as the state manager, but all the investigators have been, you know, trained in what the updates in the and what the new legislation means. So yeah, we're about to embark on our first ones actually. So if we another forum, I'll come back to you and let you know how that's gone. But for the investigator per se, as long as they're on top of what has changed, I mean, they've all got working with children checks anyway, irrespective of whether it's required for a religious body or anything like that. But it's just the timelines for some things. Can I just go back? I thought I wrote down that you said that we, as the investigator, like, I don't know if you meant we, but when you said we would have a reporting responsibility, I didn't see in the legislation that I would have a mandatory.
Oh, no, sorry, I was being the inclusive we.
Oh, right, okay. I must have missed that because...
No.
Yeah,
Okay. The relative entities. Yeah. It's the inclusive we. Thanks for that.
Thank you. Thank you for clarifying that. Yeah. So we're about to embark on some in the next couple of weeks, and it will just be interesting. I'm going to just keep a record of what is significant, what ended up being significantly different, and what just didn't really make much difference at all. So
And my experience from doing child protection investigations, say in religious-based private schools or in religious-based organisations, from that experience, I can see that there's going to be a real need in the future for educating our colleagues in those entities around their responsibilities. And really, I think that one of the things that's going to become very important for us to lead is a reduction of anxiety. Reducing their anxiety about what this might mean. Just similar to when we were going into schools, private schools, etc., about what this might mean, etc. Okay.
Ellen, sorry, before you, can we go back to that other slide? Because one of the, so I'm interested in that definition of an employee, because in recent times, lots of agencies have required staff to have working with children checks, even though their role doesn't put them in any contact with children. So almost by default, they're requiring a person to have a working with children's check simply because they work for an organisation that services children. So just looking at that definition, is that how, I know obviously that's the wording that they've used, but if you had somebody who was in an administrative role for a religious body that had no direct contact with children, but the entity had required that they have a working with children check.
Now that's a great question, Harriet, because that makes it slightly different to the other organisations that are captured by this legislation. Because, as we all know, unless because there's a different outcome for workers that are legislatively mandated to have a working with children check because they engage with child-related work, versus those that are directed by employee obligation, also by employer obligations, and the outcomes are different. Now, interestingly, and this is going to be, I'm going to be watching this space in terms of any test cases, is that the religious bodies are the only ones that have this stipulation. The other ones don't. So it'll be interesting to see if there's going to be any contest around that. So yeah, I don't know how that's going to work, but it is different to the others, because you see that this one is required by the religious body to hold, where the others don't. It's legislatively mandated. Yeah. Okay. Has anyone else come across that issue?
In my previous job, not while working for Wise, as a criminal solicitor, we used to have, and civil, very experienced civil law solicitor, we used to have instances where, before the new legislation came in, we would have a person who is going to enter a work environment, isn't employed by, but will be entering the environment, and there are children. And the organisation, the independent school, would insist that that person still have a working with children check, and there were cases where that person failed the working with children check. So, you know, I don't know if independent schools, you know, by their, you know, memorandum or something that, you know, creates them, are able to put things in that necessarily legally wouldn't stand up if somebody wanted to challenge it. But unfortunately for me, every person that wanted to challenge it failed the working with children check, and they would be going into a work environment, and I don't mean coming face to face, but they would be where children are. So that's why the independent schools wouldn't allow them in if they didn't have. And one of these people was just a delivery driver delivering things to the canteen. The company then just had to swap the delivery drivers around, so he didn't lose his job. But that's my experience with how extreme some organisations will go to, whether they're educational or religious or not. They will go to,
Yeah, absolutely. And I think that where it would have been interesting is if they did dismiss him.
Yeah, well, we asked that question, but they just said the company will swap drivers around and give them a driver and delivery person that has passed the children, working with children check.
Yeah, absolutely. Yeah. And I think
it's interesting. How would anybody monitor, to be honest?
Yeah.
Like, so he may not go into that school, but what if he goes into 3 other schools and he's failed not in a good way, failed working with children check. So he had a historical history. So it's interesting that you would think if I'm entering a workplace where there are children that I should also have to pass a working with children check.
Yeah.
I don't object to it, actually.
Yeah. And I think that this is where, again, it's going to be interesting to see where it lands, because if the legislation cast a net so wide that absolutely everybody with any contact with children had to have it would overwhelm the system.
You're right.
It's
and
very
it would overwhelm the children's guardian too.
Yeah, that's exactly right. And also, you start to wonder about, is it starting to breach people's rights?
Yeah.
So I think that's a bigger conversation. But there is some a broadening of the definition. So you can see that who is considered an employee is an individual who is employed by or is working in a relevant entity. Yeah. And again, that allows for organisations to request working with children checks for people who are not necessarily doing direct work with children. Now, an individual engaged by a relevant entity, whether directly or indirectly. So this also includes volunteers. Whether or not they require working with children check clearance, and this includes parents. So traditionally parents didn't need a working with children check, whereas now they do. And also it captures subcontractors, so contractors and subcontractors, particularly if they require working with children check clearance for the purpose of the engagement. Now, what's going to be really interesting again is going back to that conversation around is the word requires legislatively driven, or can also capture the policy or the requirements of the employer, like religious entities. Now, again, this is going to be really interesting to watch this space on whether anyone contests that and sees if there's any outcome differences between those that are legislatively mandated to have the working with children check versus those that it's an employment agreement. So we'll see how that one lands. Again, there's no clarity around that as yet because no one's really tested it out. The other employee, and this one's always been there, is an authorised carer, and also any adult who resides on the same property. Oops, sorry about that. My mouse has got a hair trigger. Yeah. Now, what's going to be really interesting here, because I was getting some legal advice on this one, is what does the word property mean? So does it mean residing in the same house? Now, when there are some situations where you've got the caravan in the backyard, and there seems to be some legal advice giving that yes, that is captured. But in some instances where you've got a roustabout living on a farm, yeah.
It's interesting. I mean, in terms of the choice of word they've put in there, I mean, like, they've got so many precedent cases for other things that would describe I'm going to say the place much better. So they use the word property. Notice they don't say resides at the principal place of residence and things like that. Like, why did they choose to use such a vague word? Do you think it was, again, a scattergun approach to broaden it rather than narrow it?
Yeah, absolutely. I tend to think that. I think that one of the things that we realised under the Royal Commission is the predatory nature of some of the...
So you're right, it will caravan, the guy living in the caravan, okay.
Yeah, or capture the bloke, or whoever living in the caravan, whatever.
Or in the flat out the back and things like that, okay.
Yeah.
Okay.
And the other one that's been captured is the visiting health practitioner, and also any staff member captured under the Member of Parliament Act.
It's very specific.
Yeah, I know. So we've got to watch out for those pollies, I think.
Yeah.
Are there any questions?
Well, we do, as we know here in New South Wales. You know, that's exactly right.
Yeah. Now, when does this apply? Because again, there was a bit of angst around: are we always switched on? Are we always looking for allegations? Now, this is not dissimilar to the Ombudsman's legislation, that for the allegation to be reportable, the employee must be employed or engaged by your entity or by the entity at the time that the allegation was raised, or when new information becomes known about a previous allegation. So the person needs to be within your organisation for the allegation to be reportable. So if the employee has already left, then it's not your responsibility to make a report to the Ombudsman. But there is a sense of sharing that information with other organisations. Now, this information exchange piece is a new piece. So how that's going to look in the future, it was the constant bane of everybody's life, that we knew that someone had committed offences in another organisation. They had left our organisation. We were now working somewhere else and we couldn't inform each other without breaching confidentiality. So this is going to be, again, another area that we're going to see how far does this extend. Certainly we can share it with the children's guardian, and then who the children's guardian decides to share it with will be up to their judgment. That's where it looks like at this point in time. But again, it hasn't been tried out yet, so we'll have a look how it lands.
Sorry, could I just check that, Eleonora? And the victims need to be under the age of 18 or 6 at the time?
Oh, 18. The child is still 18, under 18. It's under the Children and Young Persons Care and Protection Act that a child is under 16.
Thanks.
Yeah, okay. Rightio, now. Okay. So, this is going to feel very familiar to you, so I'm not going to spend a lot of time here. But what the Ombudsman's legislation did was leave quite a bit to guess, whereas the Children's Guardians legislation has got a greater degree of precision around what these definitions look like. Now, we haven't got a huge amount of time, so I'm not going to go into the nitty-gritty of each definition. I just want to give an overview, but they're pretty clear in the Children's Guardians legislation. So it's still an allegation-driven scheme, and the definition of reportable allegation hasn't changed. It's they engaged in conduct that may be reportable conduct. And we've also got the reportable conviction. Now, what I believe it's, if I remember correctly, it's the same as the Ombudsman's legislation, is that it's the finding of guilt but without the court proceeding to a conviction. So that's extending it slightly. And now the definition of reportable conduct has the subcategories that you can see at the bottom of the screen there. There's your sexual offence. Now there's a greater degree of precision around these definitions and how to and what to consider when trying to make a finding. So there's the sexual offence, the sexual misconduct. Now the sexual misconduct doesn't necessarily mean there has to be an actual event, but with the intention of. So intent of a sexual nature has now become a litmus test for this. And you can see that there's others as well. Now these are the definitions of sexual offence and misconduct. So you see that there's a sexual offence it relates to any legislation. That's the same as it has always been. One of the things that has changed and has become a lot clearer, particularly since the Royal Commission, is that grooming is now a sexual offence. Now, the challenge with that is, what is grooming? Like, having worked in child protection for so long, and I specialised in child sexual assault, is grooming, touching a child on the shoulder to congratulate them on a piece of good work, an act of confirmation, validation, care, or is it grooming? So this is one that's going to be an interesting one to watch. Has anyone got an experience of making findings solely on the issue of grooming? Does anyone? Oh.
Certainly under the previous legislation, yes, lots and lots of grooming.
Yeah.
It's very common. But I think what I noticed, the difference with our previous legislation was that grooming fell pretty much into sexual misconduct, and so you could wrap up a lot of behaviours that would be grooming but without the sexual intent necessarily. You put that into sexual misconduct. So I was quite interested to see that's changed here. And in Victoria, the legislation they've brought in Victoria, in light of the Royal Commission, reflects the same thing. So grooming's in there, but it has to really meet the criminal threshold. Yeah. Which is how this appears to me, that they've moved grooming to the criminal threshold of grooming, where you have to demonstrate sexual intent.
Yeah.
And taken out of the sexual misconduct, which I think is clearer.
Yeah. Has anyone defended anybody who's had the grooming offence brought against them?
A long time ago, back with legal aid, yes. So again, typically they were mainly school teachers, to be quite honest, or school teachers with a responsibility for some sporting training at school, so that sort of thing. Even last year, we've undertaken an investigation where the allegation was grooming, but it was a teacher. And your point, Harriet, about, yours, Eleonora, where, the person touches the child. So they make physical contact, there's no doubt about that. The intent behind the physical contact was the thing that in the end, so the teacher, for example, was saying they were demonstrating a criminal offence, and the criminal offence involved murder. So there was certain touching required because the child had asked a question, what does garrotting mean, for example? So there was some physical contact, but then it turned into that was, inappropriate sexual. I don't understand whether sexual, although you had to determine whether there had been any other behaviours leading up to that made the child think it was, of a sexual nature. But only criminally working for legal since that was the closest to a grooming type one that we had.
Yeah. Okay. Yeah. It's always one that's been it creates the greatest angst because it's the intention behind it. But we know that it is implicit in the sexual abuse dynamic. So it's always been a headache. Now, the other ones that are coming and that are changes, and I think it's well overdue, is that when we're making decisions around professional boundaries, and, you know, is it misconduct? Is it whatever? The definitions that and this is a mandatory consideration. At the bottom of the page there, of the screen there, you'll see that the definition requires the decision maker to have regard to professional standards. So are there professional standards that influence practice, you know, in terms of, you know, certainly for social work and psychology, there are some definitely clear practice standards. Also, that we need to take into account codes of conduct. So one of the things is, as investigators, that we will be really curious about, and certainly trying to encourage all organisations to develop, if they haven't developed them already, are very clear and precise codes of conduct. So what's the organisational expectations? Because from the investigations that I've done that were really difficult and fraught, it's in the absence of really clear policies that there's a lot of wiggle room to justify quite unreasonable behaviour. The other thing that's new is accepted community standards. Now, these are the 3 litmus tests that decision makers have to take into account, so that one of the things that I'd also see that's going to happen in the future is conversations with heads of HREs to make sure that all those policies and procedures are in place. My experience, particularly working with smaller agencies, is that they have very undeveloped policies and procedures around codes of conduct or, you know, employee expectations, etc. So there's going to be, I think there's going to be some fertile ground to really support agencies to develop these, because these are the 3 mandatory considerations to make a decision and a finding. Okay. Now, in terms of reporting, all relevant entities have to notify reportable allegations that are work-related. Now, there are also those that are required to report allegations that occur outside of work. Now, this is a nice piece of clarification under the Children's Guardians legislation, because there was always anxiety around people's conduct outside of the workplace. And then, but that conduct wasn't witnessed inside the workplace. Now, what we saw from the Royal Commission, and let's face it, anyone who's worked in child protection for 3 minutes knows that if you're going to sexually abuse children outside the workplace, there is not necessarily an undeniable inevitability about it, but the likelihood of abusing children inside the workplace is higher than those that don't abuse at all. So the outside the workplace has been captured, which is long overdue and very welcome. Now, those that have to report both inside and outside are Schedule 1 entities, which was what we looked at before, religious bodies, and particularly for all persons engaged where they require working with children check. And that includes both legislatively mandated and also those that are required by the employer, and also public authorities that aren't part of Schedule 1, where the employee needs to or is required to hold a working with children check. Now, what's going to be interesting is those that don't necessarily have to hold a working with children check, but have a history of harming children outside the workplace. Again, we don't know what that's going to be looking like when the legislation kicks off. Are there any questions around that one so far? Yeah, it's very welcome. Yeah, this bit is really welcome. Okay. All right. So the question is, what applies to whom? In terms of a reportable allegation and a reportable conviction, this applies in terms of Schedule 1 entities. It applies to every employee inside and outside of work. So there's a very broad catchment area. This was an area that often created a lot of discussion around what if an employee harms their own children? And that's been clarified significantly now that it's both inside and outside. The other one is with a public authority, any employee that's got working with children or requires a working with children check clearance inside and outside, and those that are employees not required to hold a working with children check clearance inside work only. So we've got to have a look at, when we're doing investigations, what's the requirement to hold a working with children check clearance? Now, this one can be tricky because some organisations, some employees aren't required by law but are required by their employer, and it's going to be interesting to see what happens. And also the legislation takes into account historical conduct, which is fantastic, and historical conduct that cross boundaries and borders as well. So someone could have been harming children in the Northern Territory and now they're living in New South Wales. There's always been a capacity to do that, but it hasn't really come up as clearly. Okay. Any questions so far? Rightio. Now, in terms of religious bodies, this is the new frontier, and I think that this is going to be an interesting space to work in. One of the things that's quite clear, and the Ombudsman certainly gave clear messaging when they held this legislation, and the Children's Guardian is giving clear messaging around this as well, is that the absence of any sorts of reports is also a trigger for curiosity. So if you've got a religious school that has absolutely no reports going into the Children's Guardian, it's like under the Ombudsman's legislation, it always invited a curiosity about how diligent or how well that organisation is managing their responsibilities. Do they have the correct policies in place? Now, as we all know, this is another piece of beneficial legislation. So there's always a conservative interpretation of the legislation. So there's going to be some, it's going to be very interesting to watch what happens in the religious organisations. So religious bodies have to report reportable allegations. Now we know that under the Royal Commission, there is a bit of a history, or how should we say, there isn't such a strong history of making those reports. So this is very explicit to those organisations. So any employee, volunteer or contractor who holds or is required to hold by the religious body working with children check for the purposes of engagement and employment, whether or not the conduct occurred in the course of the employment or engagement. So it includes everybody, it captures everybody inside and outside of work. Any questions on that one? Can anyone predict any challenges that might bring up when we're doing our investigations?
No, but my question to all of you was going to be, how do you see, even though this is specific to religious bodies, how do you see it impacting on child facilities? Because there's a lot that comes out of that as well. In terms of, I've got contact with an organisation who, interestingly, says they're the most reported childcare facility in New South Wales, for example. But interestingly, they use that as a positive. Like they say, what that means is they're reporting it, by the way, not other people. And they said that when they were working with the Ombudsman at the time, that was taken to show or be a demonstration that their reportable conduct processes and practices were working really well. What do you think of, what's everybody's attitude towards that? Because if you were a parent, sussing out which childcare agency to put your child in, do you think you would put your child in the most reported agency or the least reported agency? So I'm using that analogy to say, when you think it's suspicious that a body hasn't reported anything, what do you think the take on that would be if a childcare centre hadn't reported anything as opposed to the most reported agency in New South Wales?
That's a great question.
Well, do you think you could draw any conclusions either way? So that's the point I'm trying to make about, one, that you'd be suspicious of an entity not having read anything. Do you think that it's reasonable to be suspicious, or is it just because they're religious bodies and we don't have any faith in them, perhaps?
Yeah, I don't know if there's any easy answer to that question. Yeah. What concerns me with this particular piece of legislation in regards to religious bodies is the conduct outside of work for potential contractors. So people who are employed for very short pieces of work with religious agencies who are required to have a working with children check, would they be aware of the new rules that apply to them across their whole of life? So I think pretty much people get what they're not supposed to do with other people's children. But if you look at the prevalence of domestic violence, And where that clashes, I think there's some really, you know, I think there's a lot of whole of society education that needs to go with this for it to really, for it to really work in this way that it's meant to be working.
Yeah.
So I'm just conscious at the moment, Eleanor, of the time. So we've got sort of 15 minutes left, and I just want to make sure that we get to some of the end slides, because I know there's some good information in there as well.
Absolutely. So we'll skip along. Yeah, an hour just evaporates, doesn't it? So here we are. This is a clear message, and I think it's a really useful message from the Children's Guardian around what we need to be looking at when we're trying to make a finding. Because one of the things that I certainly noticed in the time that I've been working in the field is that the challenges of making this decision often led to avoidance or an anxiety about doing the right thing. So the legislation is quite clear, is it to make a finding of reportable conduct. We need to, it's based on a balance of probabilities, which is the same, but it's based now on the nature of the reportable allegation. So the things that will be coming into here is what's the behaviour, but the other thing that will be coming in clearly here, and it's much more explicit in this legislation than the previous legislation, is taking into account the nature of the child themselves. So what's the vulnerability of the person that was harmed? Is that behaviour, if it was against a 15-year-old or with disabilities, is it the same if there's a 15-year-old with no disabilities? So taking, there's a lot more to think about, and also the gravity of the matters alleged. So again, it's looking at placing that in the context of the nature of the child, their vulnerability, and also around risk management. Around, are there other children? Is the target group that we're servicing as an agency have highly vulnerable clients and customers? And those are, again, on the other side of the page, you see that those are the three areas that we need to take into account. Have they breached professional standards? Have they breached codes of conduct? Is this within or outside accepted community standards? So it's really nice that this has been clarified, actually. The other thing that that I've flagged already is exchange of information. Now, again, this is a bit of a new piece, because we now have the Children's Guardian who is able to share information with other agencies, and other agencies can share with the Children's Guardian. What we also need to look at is, can other agencies share information with each other about someone that they're worried about? Now, the section of the legislation, I think it's section 57 or I forgot the number, doesn't necessarily extend to other agencies. So it's going to be interesting to see how we do that. However, what we do know is that agencies can exchange information under Section 16, Chapter 16A of the Children and Young Persons Care and Protection Act, if they're worried about the safety, welfare and wellbeing of children, and they believe that they're at risk of significant harm. So it's unclear yet how this section of information exchange is going to articulate with existing pieces of legislation. Has anyone had an experience around that yet? Yeah, this is going to be interesting to see how the Children's Guardians legislation articulates with the care and protection legislation, and also the Crimes Act in terms of disclosing a serious offence, etc. But what we do know now is that the Children's Guardian can share information interstate and also with the Commonwealth, and also with investigative bodies. So this one's going to be interesting. Investigative agency isn't necessarily defined really clearly in the legislation. So does that mean private investigators as well? Not sure about that. Has anyone got any information around that or been told? Yeah, no, this one's going to be an interesting one, whether it means private investigators. Okay. Now, what's new in the legislation is that now we have very explicit protections for whistleblowers. So that Section 64 protects the whistleblower from making a reportable allegation in good faith. And also, it makes it very clear that it's an offence. Now, it's not, they use the word offence very clearly in the law, that it's detrimental to take action against a person providing information about a reportable conduct, whether make a report, a complaint, or a notification. So that was missing from the Ombuds, and it's very clear in this legislation. Okay, now the thing with this legislation is that there is the Section 57 talks about must, as we all know, that there's obligations there. So the presumption is that information will be shared and exchanged unless there is compelling evidence against it. So the presumption is that information will be exchanged, and it will be exchanged with, and there will be information sharing with the child, the parent, and if a child is in out-of-home care, with the authorised carer. Now, the only reason that information, now how much is going to be shared is going to be based on the public interest argument. So it's about whether, when, how much and how it's going to be shared. But the presumption is that it will be shared with the child, it will be shared with the parent, and it will be shared with an authorised carer, unless they are the person subject of the allegation. And then it will be a consideration about how much. And the information that needs to be shared is around progress, what's happening in the investigation, the findings, and any action to be taken. You don't have to go into great detail, but some information needs to be shared. It was, again, a recommendation from the Commission around the secrecy that was involved and the dissatisfaction of the community around the way that organisations conducted their business around investigations. Does that make sense? Okay, fantastic. Yeah. Now, this is interesting. Under the old legislation, it was 30 days from when the head of agency became aware of the allegation. That's now been refined, so it's now 7 days. In actual fact, the Royal Commission recommended 3 days. The Royal Commission was very enthusiastic, but we landed on 7 days. Now, interestingly, is that failure to comply with the 7-day ruling now is actually a penalty, and it's 110 penalty units. So it's a bit of a fine for agencies. I'm not sure whether the Children's Guardian is going to really want to impose those fines, but certainly it's an incentive. It reminds me of the old mandatory reporting days if you fail to report child abuse. And I don't think there was that many fines ever issued out, because we don't want to disincentivise reporters. But what we do have is a much clearer guide around when we need to touch base back with the Children's Guardian. So you've got 30 days. So 7 days to report when you become aware, and you have to have either interim report or final report within the 30-day period. This is trying to manage investigations that went on forever. And that was often by inexperienced organisations that weren't clear about how to undertake investigations. It really cut across the natural justice and procedural fairness to the person subject of the allegation. Okay, so in terms of the changes, there's greater certainty about what needs to be reported. We all, I'm sure, came across investigation reports when we were called in to do some work that were not all that helpful. So there's a greater certainty about what needs to be covered. It needs to be the date that the report was received, the type of reportable conduct, the name of the employee, the entity, whether police have been notified, whether DCJ have been notified, any other relevant information that is pertinent to the allegation. And also then we've got to have that update status within that 30 days. Now the penalty only relates to the 7-day period. It doesn't say anything about the 30-day period. So we'll see what happens there. And the other thing that's really useful is that it really streamlines all those reportings that we had to do. There was 3 different reports for one activity, which was ridiculous. So this is a nice tidying up by having one agency do all the umbrella work. Now, the other thing that the changes have brought in is that previously having a reportable conduct program was part of an out-of-home care provider's accreditation process. That's been abolished. That's no longer part of that. So the intention is to have a carrot rather than a stick, is to invite people to be child safe organisations. Okay. And this is just quick. These are the standards. I don't think we've got time to go into this. But certainly the Office of the Children's Guardian is inviting everybody who's undertaking investigations or supporting agencies to develop and implement child safe practices to not only adopt this in principle, but to implement this in practice as well. I'm working with a number of organisations, helping them develop implementation plans on how to embed the child safe standards as business as usual. Now, this is not it's not obligatory at this stage, but eventually there's going to be a time frame where all agencies need to have this in place and have evidence of having this in place as well. So again, I'll let you read that. But as we come to the last minute, are there any questions or any issues that people want to share or tap into the wisdom of each other?
I have a question.
Yeah, Wendy.
What often comes up during investigations, particularly where there's perhaps family court issues and potential false allegations, is there anything in the legislation that addresses correcting the record? For instance, if there's a false allegation that's been made and or someone has been placed on the register where perhaps there hasn't been sufficient evidence to for them to be on that register.
Yeah, that's a really interesting one, because I think it's a watch this space, because I was looking for the vexatious, malicious finding, and it's not in this new legislation. Now, we know that a person's right to expungement hasn't been removed by this legislation. So yeah, that's a great question, Wendy, because it's not clear in this piece here. It's either you either have a finding that you're satisfied that reportable conduct has occurred or not. So yeah, that would be a really interesting one to see, or it'd be a really interesting one to ask the Office of the Children's Guardian, because the legislation's silent on it. Has anyone got any other tips about that particular issue? Because that's a great one.
Well, my experience with that is people legally trying to have change. So I don't, and they were just taking legal proceedings. They were going to the civil tribunal to try and get it overturned. So I don't know, and some of those cases I haven't dealt with for a very long time. I mean, some of them were successful, to be quite honest, civilly. They, because when it's there on register, I mean, they do have to take the civil proceedings themselves. So you're right, there isn't anything in the Act that covers it. And it's interesting why, because it does happen. Yeah. I dealt with a whole government department that, I don't mean decided, the legislation required to ensure, for example, that certain out-of-home carers all had working with children checks. So you had these anomalies occur where there was a husband and wife that were looking after her for a government department, a stream of children. So without naming them, you can guess what sort of, situation I'm talking about. The husband actually failed the working with children check because he and his current wife, had had sex when they were minors, ultimately went on to have a child and get married. But the woman's father reported to the police and he got charged with and found guilty of sex with a minor. So there we go, having that. So there was this issue of that he was on the child sex offender register and trying to have that rectified. So my only experience is taking actual civil proceedings to try and rectify it. There hasn't ever seemed to be anything in any act that will allow a person. I think they don't want to get into that. I think they want to put that to the side and go, if you believe you can prove that it was vexatious, malicious, or not satisfied to a standard, you need to fix it up yourself. I don't think they want to take part in that process. That would be then them getting involved in legal proceedings that they really don't want to get involved in.
Yeah. And I guess that the other thing that speaks to, because I mean, I think you're right, it's a really fraught area, and those examples we hear them everywhere. Yeah. I guess it's a real imperative for agencies to have risk management program. So what risk does this person pose in reality? So again, as investigators, we would really invite organisations to be robust in codes of conduct, professional standards, risk management strategies, etc. Because that has come up frequently. So to answer your question, Wendy, the legislation's silent on that one. Maybe it's something that we talk to the ombudsman. But in terms of, not the ombudsman, the children's guardian, but some of those offences are criminal offences, and the children's guardian doesn't have the mandate or the ability to overturn a criminal offence. So, it's what's the forum that we do that in would be a great conversation to have. Okay. Well, listen, gang, it's 12 o'clock.
Yeah.
And I feel like we've just started. I could have gone on forever. Oops.
Thank you. If I can just thank you very much, Eleonora, for sharing all your knowledge and insights into that new piece of legislation. And as I say, it will be about watching that space and working out how the new bits of legislation all come together when we're actually dealing with matters that are in front of us. So thank you very much for that. Before people jump off the line, I just want to say that now I've reconnected with Eleonora, we're going to be working on an online course for forensic interviewing of children, which I'm going to give a nudge to Eleonora because I'm really excited about that coming into fruition. So hopefully that will be available in the not too distant future. And we're continuing our webinar series, and the next one we've got in a fortnight will be on mental health first aid for investigators and people dealing with complaints and misconduct. So hopefully some of you will join us for that one. So thanks very much, Eleanor. That's terrific.
Thank you. Thank you too, Harriet. Very much appreciated. Thanks, Eleonora.
You're welcome. Thank you. It's lovely to meet everybody.
Okay.
Bye.
Bye.
Bye.